Hi, welcome to another episode of A Little Privacy, Please. I'm Jason Kravitz, and along with me, as always, is Jenny Holmes. We are delighted to have the first person who I think is our second-time guest on A Little Privacy, Please. He did one of the earliest episodes. It's our colleague from the Chicago office, Jason Kunze, who's an IP lawyer, tech lawyer. Jason's going to help us get smart on the recent settlement in the Anthropic case, which is a copyright case that is getting a lot of attention, garnering a lot of attention in the AI world. Jason, tell us about this Anthropic dispute. Maybe give us a little background, and then we can dive in with some questions.
So the Anthropic case is really exciting because it's one of the first decisions we have on the AI and machine learning front where you have a company, and there's a number of them. There's OpenAI, there's Microsoft Copilot, there's Meta, there's Anthropic, and others that are pulling in these huge data training sets and using it to build out their tools. Anthropic's tool is called Claude, and the way Anthropic went about getting its data for Claude, they did two things. The first thing they did is they got these data sets online, these pirate data sets. One of them is called LibGen. There's a couple others that have about 7 million books in them. And they use that data, or at least some of that data, to inform Claude and train Claude. The second thing they did is they bought large groups of books from publishers and resellers, truckloads of books that they could scan into their system. And they bought those subject to license agreements.
It's really significant that there are two different buckets here, right? They're the books that were purchased and then the books that weren't purchased, right?
Exactly. And for the books that were purchased, the court issued an opinion on that and said, that's okay. That's a very transformative use. Under copyright law, as you know, when you think about fair use, there's a multi-factor test, and it's very case specific. And in this situation, the court looked at it and said, this is super transformative. You're taking this information, you're using it for all these different applications. So to the extent you purchased these books and scanned them and used it for this specific training, that's okay. But the court also said, remember that set of 7 million books where you had pirate copies? And by the way, Anthropic didn't necessarily use all those for training, and they kept the pirated data set. The court took real issue with that. On the heels of that decision came this proposed settlement. And I will mention it's proposed. The court's initial response to it was, this agreement isn't very strong, and we've got to address a lot of things. So we may be a month away from seeing whether or not that settlement goes through. But there was a big number, $1.5 billion, in that initial settlement that I'm happy to talk about further.
So I know we hear $1.5 billion. It comes out, I think, to about $3,000 per author. Is that generally in line with what we see in these types of cases, or is that still a large number?
Well, it could have been a lot bigger. And what Anthropic was looking at is they were potentially going to trial. And it's important to distinguish between the full library of pirated works, which is about 7 million works, and what they're actually settling, which is about 500,000 works that have been registered with the Copyright Office. So for those registered works, you're entitled to statutory damages. And those can range from $750 per work to $30,000 per work, or even more if there's willful infringement. So that's a pretty big range. Obviously, $3,000 is toward the lower end of that range, but you also have to figure that the plaintiffs had a number of risks going to trial. And this is a very new subject matter area. The court other opinions may come out that go in a different direction. Anthropic had some other defenses. So is $3,000 a good deal? I mean, obviously Anthropic thinks enough of it that they're willing to try and sign off on this. It tells you something about the value of that data set. It also tells you something about the difficulty of individually licensing from all these authors, which would be nearly impossible. So in a way, the plaintiff's class has done Anthropic a favor by pooling all these people together.
Help me understand something, because I'm not clear on how, if Anthropic purchase purchase these books. Sort of let's just say it's 50% of them. They purchase 50% of these books. The other 50% you called from a pirated database. What is the source of that? Where are they getting access to these pirated books?
Yeah, so there's some common databases that are just basically floating around online that pretty much anybody can get access to. If you go back 15 years to when everybody was, not everybody, but a number of people were pirating movies, or peer-to-peer networks were a big deal. You could get almost any initial motion picture release online, like 2 days after it came out. So folks have built up these large libraries, and I think Meta has actually used the same libraries, and that's addressed in a decision that came down about 2 days later. But it's available. But if you want to use it, I think everybody knows that they're not legitimately licensed works, so there's risk around that. And folks are looking at this and saying, look, the value in getting that huge set of training data outstrips the risk, and we're going to go ahead and do it and figure it out later. And I think that's what's happening, and now we're figuring out what the price tag is on that.
So it sounds like for a lot of these AI tools that have to use huge amounts of data to train their tools, this might just become a cost of doing business.
Yeah, well, I mean, it's hard though. Even if they want to pay for it, how do they contact all these individuals, right? There's a number of orphan works out there where we don't know who the author is. And I have no doubt that Anthropic is interested in formally licensing those works and may not be able to contact some of those people. It's very hard for those companies to find an avenue to do that licensing. It's an extremely high cost. In other contexts, and kind of the obvious example would be like music licensing, you end up with some of these blanket license agreements where, if I'm running a bar or a restaurant and I play a group of songs, then I pay a certain amount based on the ASCAP and BMI rates and all that. And there's a rate setting court that does all that. We don't have any of that infrastructure in place on the AI side, and I'm not even sure that blanket licensing would work. But in the absence of that, there's not a lot of other avenues available. And again, the value of this training data is so high for these systems that, maybe if Anthropic and others can pay $3,000 a work, maybe that's a reasonable price.
Well, this is a huge settlement, and I know everyone's talking about it in the AI space, and it's going to have reverberations probably for some time to come. But your point's well taken earlier. This has to start with getting the judge's approval in the first instance, which is not a sure thing.
Yeah, absolutely. And because this is the first settlement of its kind, it's going to be an anchor for future negotiations. So if that $3,000 number holds up, obviously when, Meta in the next month or two or one of these other entities is having the same discussion, surely somebody's going to throw that out as a starting point, and we'll work from there.
Well, Jason, thank you for jumping on short notice. We've all been following this case and the updates that happened just last week. And that'll do it for this episode of A Little Privacy, Please.